want to make sure that the children are brought up in a family. Russia and America are not getting on very well at all. But if you go to Moscow, you will find American lawyers, American medical doctors, American businessmen. If you go even to New York, the same thing, you'll find Russians. To have a relationship, you do not have to be friends at all. The fact that the president now and the deputy president do not talk to one another, it does not matter. At the beginning, they were talking very well. They were talking to one another very well. Rachel and Rachel and Dorcas were great friends. Some of us were very happy that you could say two wives, two presidents, all of them looking like people of the same family. That is the culture we want. That is the stabilization we want. That is the peace we want, so that we make sure that we can develop our economy. But not this kind of quarrels and so on, and where one now is able to convince others that we cannot work together, therefore we must divorce. My humble submission, Mr. Lord Eric Ogola, who is as you are presiding over the bench, please come up with a judgment or come up with a ruling that you are not going to lift these conservatory orders. If you do so, you will be opening a chapter for this country which we may not be able to handle at all. Currently, let me remind you again, the deputy president is enjoying poll rating of 70% in the whole country. He has attracted sympathy votes from people who like him. And the Parliament or National Assembly, which actually impeached the deputy president, if you go through what happened, was a disaster, was disappointing. It is not something to be emulated at all. If you go to the other house, the Senate, again was a disaster. Can I continue, my Lord?
Please wind up your submissions.
I'm winding up. I'm winding up. And I'm winding up on this note. My Lord and my Lady, I have lived enough in this country, I've lived long enough in this country, and in particular in Nairobi. When you hear a rumor, do not be so small-minded and dismiss the rumor at all. The rumor usually has got some truth. So that when you hear Paul Mwita has been bribed, don't dismiss it quickly. There may be truth in it. When you hear Kibe was seen with so-and-so, don't dismiss it quickly. There may be truth in it. This is the ability that Justice Madden had, and that's why he was able to rise to where he was. The ability to be able to know what's going on in the country and so on. We are a corrupt country, and Bashar still controls the country. It controls Parliament. It controls Senate. Let it not be said it controls judicial. Thank you.
May it please you, Lord President of the Court and the members of your court, we are happy to reply to our colleagues. Somebody has come from the woodworks.
and the leadership. My name is Mosongo. I appear for Sharia alongside John Mariri. Sorry. I was just requesting for 5 minutes.
I'm on high demand, so I beg to leave the court. I'm going to deal with some other matters.
My Lord, just a clarification whether Kituo cha Sheria was enjoined. Last time Dr. Aminwa made an application for Kituo cha Sheria to be enjoined, and then you enjoined Dr. Aminwa himself.
Yes, yeah, that was done.
Yeah.
Yes, Kituo appears now as seventh interested party. I proceed? 5 minutes.
Your name?
My name is Mosongo. I proceed?
Yes, please.
Thank you so much. Your Lordship and your Ladyship. At Kituo cha Sheria, our slogan and motto is that we care for justice. Our intentions at all times is to uphold the Constitution and ensure access to justice. And we have been, for the past 50 years, been recorded as an organization that promotes that. For sure, I'm not 50 years, but I do stand on the shoulders of giants who have been there before me. And I want to just bring out 5 points in my few minutes. Why you shouldn't vacate the orders or fail to ensure there is conservatory orders. Number one, in promoting justice and the interest of justice, we have petitioners who are saying that their right to fair trial and constitutional rights have been contravened and violated. And it will be so painful for them, genuinely speaking, that conservatory orders be lifted, vacated. Then they continue with the trial. For sure, Article 23, Article 159, Article 27 talks about ensuring equal playground. Our argument is that your Lordships and your Ladyship, to ensure that their constitutional right to fair trial, even including during this process, so just preserve the few days that you guys will be handling the matter, that status quo be maintained, particularly because it is crucial for public interest.
Judges are not guys.
My apologies. Yes. My apologies. My apologies. Your Lordships and your Ladyships. Your Lordships and your Ladyships, if I may proceed. It is indeed in public interest, genuinely, that, and for stability, that for sure status quo be maintained, not only for the current president, vice president, or even the nominee of the president, because you know it said ukiona cha mwenzako, kichwa cha mwenzako kimenyolewa, chako kitie maji. It is critical even for future vice presidents to deputy presidents to have their rights safeguarded, and at least the courts provide a guideline on how Article 145 is to be exercised. And for sure, we also think that and argue that procedural integrity and legal precedent that you are at this point making, your Lordships and your Ladyship, it is important that the court at least safeguards the petitioners who are claiming their rights have been violated, and they need a conservatory order pending the determination and final outcome, so that it doesn't embarrass the court ultimately when now you make a finding that for sure the entire process could have been flawed. We argue that to also avoid arguments that possibly there would be potential bias, we encourage the Lordships and the Ladyships to really consider that, as I wind up, that let's ensure that there are no allegations from both sides that justice was not served. It's imperative that at all times justice be seen to be done. in line with Article 159. And lastly, they are arguing, the petitioners, that irreparable harm will be occasioned upon them. And it is in the interest of justice that they be accorded that one final bullet, last chance to be able to benefit their right before the final outcome of this honorable court. I humbly pray that your lordships and your ladyships, please do not vacate the orders. Thank you so much.
Thank you very much, presiding judge and the members of your court. I want to guarantee you from the outset that we will not use 4.5 hours for the respondent. We will be very, very succinct. Indeed, we may very well use half that time. Every lawyer in this court is entitled to his opinion as to what the law is. There is only one thing they are not entitled. It doesn't depend on their opinion. It is what the facts are. That's where we need to start. What are the facts that are relevant to you determining whether conservatory orders should continue in force or should be vacated? It is my humble submission that the pertinent, the material facts are as follows. On the 17th of October 2024, the Speaker of the Senate gazetted the removal from office of the former Deputy President, the Honorable Rigathi Gachagua, by dint of Article 157, sub-Article 7. It is important for us to go there, my Lord, and it will take half a minute. What is the language of 145, sub-Article 7? It is this: if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, any, the President shall cease to hold office. That's the language, shall cease to hold office. As at the day and the time and the minute that Senate voted, the Deputy President ceased to hold office. I hope this doesn't disappoint my learned friend Teresia Kemodo of Teresia Kemodo and Company Advocates, who wants an apology. The Deputy President ceased to hold office. But something else happened. An intervening fact is that on Friday the 18th of October, via a special sitting of the National Assembly, the Honorable Professor Kindiki Kithure, pursuant to Article 149(1), having been nominated by His Excellency the President, was confirmed by the National Assembly. It voted on his nomination. One person has ceased to hold office, another person has been appointed, has been nominated, and the body entrusted in law in affirming that nomination did so. That was at 1:30 p.m. on Friday the 18th of October 2024. What then did the honorable judges of the High Court of Kenya conserve? What were they conserving? There was nothing to conserve. In the logic of the law, we've been told that, a lot about why the Constitution is very important, why it's very special, why it's very transformative, why it's not like the Constitution of other countries. It may very well be all that. But the Constitution is a law to interpret, to be interpreted the way we interpret all law. When we read a will, we don't start searching for the spirit of the will, because the will is speaking. It is saying, I leave my assets to my son, to my daughter, to my uncle. So a person reading a will doesn't tell the family, before we read the will, let us capture the spirit of the will. If we read a tenancy agreement, we do not say, let us capture the spirit of the tenancy. The tenancy agreement is speaking on its face until there is an ambiguity, which is the same thing with the Constitution. It says what it says until there is an ambiguity. Where is the ambiguity when the Constitution has said, shall cease to hold office? It is our first submission. There is no ambiguity. There is no reason to search for any other meaning, any other spirit, any other constructiveness. The petitioner is aware of that. There is an affidavit here called supplementary affidavit in support of the petition. What does it say in paragraph 22? In this case, however, Kithure Kindiki was unqualified because he had not been a member of UDA political party for 3 months preceding the nomination. He was ineligible for nomination to the elective position of deputy president under Article 37 on the 18th of October 20, when the vacancy arose. This is not the Attorney General's affidavit, it is the petitioner's affidavit. So that his lawyers may be acting contrary to his express instructions, because he has sworn an affidavit in which he acknowledges that that office became vacant. It is our second submission that when the so-called conservatory orders, and my colleagues will demonstrate that these are not conservatory orders, these were mandatory injunctive orders of a nature not contemplated by the Constitution in this circumstance. At 1:31 p.m., when the conservatory orders both were issued, both in Kerogoya and in Nairobi, there was nothing available to conserve. The substratum of their complaint had been overtaken by events. And so much so, my lords, that, and my learned friends will take you through this, there are several judges who were approached to give conservatory orders, including this bench, and you said there are matters here already overtaken by events. That news may not have reached other parts of the country. Very briefly, I will argue the public interest. My lords, this constitution is a constitution to protect everybody. Sometimes it is cited as if it was tailored only to protect a section of the society in Kenya. It is for everybody, including the institutions that it establishes. It is to protect the judiciary. It is to protect the legislature. It is to protect the executive. We are told continuously that the executive is a problem. The executive is a problem. The executive is also protected by law. The president has a power donated by this constitution to nominate a deputy president. He did that. He has a power to send that name to court, to parliament. He did that. Parliament has a power to vote on that vote. It did that. But it is being suggested that that in itself finds no protection under the Constitution. What finds protection in the Constitution is the conservatory order that came from Kirogoya. Kirogoya, yeah. A place called Kirogoya. We were told, my lord, and this is true, that the impeachment process is a special process. It's sui generis. It is neither civil nor criminal. It's a process sui generis. And that is why, and this cannot be said many times, enough times, that is why the framers of the Constitution do not say that a vice president will be brought to the Supreme Court of Kenya and tried for violations of the Constitution. It is a political process. It goes to a political chamber. Senate sees as a political body. That's what happens in there. When Dr. Kaminwa says impeachments are never successful in the United States, it is because of the peculiar politics of the United States. Because the impeachment process, even there, is more political than it is here. So we must have fidelity to law, my lords. It is our submission. If you read through the case of Kiriro Ngugi, it is in our bundle, and I will not. And if you read the case of Martin Wambora, Kiriro Ngugi is instructive. This is what the court said, and I'll be very brief. A court must satisfy itself that the case before it is not caught up by the bar of non-justiciability. The concept of non-justiciability is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. Thirdly, the ripeness doctrine. Actually, much was said about justiciability. This is not new law. This is old law. It is thousands of years law. It's thousands of years of English law. The first thing the judge would ask is, what is your course of action? You must have a course of action. The court is not a forum where litigants can hold an academic debate. The judge will always ask, what is your course of action? Okay? Now, so the doctrine of justiciability may sound new, but it is as old as the common law. What is the political question doctrine? We are not going to argue it, but it is actually straightforward that the Constitution recognizes that it has donated power and authority to several institutions, and each institution should keep to its lane. We have developed a constitutional law, or we are developing a constitutional law here that actually invites contravention of the Constitution, and it is this: that every conceivable social, political, cultural, economic grievance is capable of a constitutional resolution. How is that? How is that? It is not possible. And that is why in our political social system, we have a million other ways of resolving conflict. Not all conflict is justiciable. Not all grievances are amenable to a constitutional solution. Now, let me go to my second last point about I want to take you to the case of County Government of Kissy and two others versus the Independent Electoral Commission. It is a 2024 decision, and this is the last thing I'll say before I invite my colleagues to come in. The gracious lady will not have to bang her gong. This is what the court said in that matter. While guided and applying the foregoing, in this case, the law does not anticipate that the office of the deputy governor shall remain vacant indefinitely for whatever reason, having so held that gazettement is a mere administrative formality and taking into consideration the circumstances of the instant case, whereby nomination and approval by the County Assembly of Kissy was undertaken way back in April 2024, it would be unconstitutional to further delay and postpone indefinitely the filling of the vacancy of the office of the Deputy Governor of Kissy. That's what that court said. Finally, because I'm still within time, the Wajir case shows that our constitution has self-correcting provisions. What happened there, my lords will remember? Yes. Is that the governor had been impeached. During his impeachment, the deputy governor assumed the high office of governor. He went to court. After a long litigation, the court found his impeachment was wrong. And then the court said, reverse the order. Just to use an expression by my learned friend, I think it was Mr. Kiba Mongai, the law is organized. The heavens didn't come down in Wajir. The law said, go back to your office, and the rest of you go home and do something else. That is how to ensure certainty, predictability, stability. That is what we should have here. We are here. I am told on behalf of the Attorney General to assure you that for as long as this matter is litigated, the law will be observed. If a day comes when anything needs to be reversed, that will be reversed. But for now, the public interest is in continuity. Thank you.
Yes, my lord. Your Ladyship and my lords, let me dive right into my submissions, and I will demonstrate, my lords, that contrary to the submissions made by my learned friends, Articles 47, read together with Articles 50 and Article 25(1)(c) on the right to a fair hearing, were complied with. And I will show, my lords, that as of the time that notice was received in Senate by the Speaker on the 9th of October 2024, notices were issued to the petitioner to file all the documents as prescribed and to defend himself to every question that was raised in the National Assembly, which, my lord, you recall, had voted by 282 members to impeach the Deputy President. The right of fair trial, fair administrative action under Article 47, and the right to a fair hearing were therefore preserved. And I will just demonstrate as I move on to show that once the 16th and the 17th were gazetted as the dates when the Deputy President would be heard, and that would be the Wednesday and Thursday of October 2024, the motion, the 7-day period when motions and pleadings were exchanged, then commenced. And all parties were aware that the Senate investigations would take 2 days. Your Ladyship and my lords, parties were then invited to respond to every allegation. This was a two-tier trial, my lords. The National Assembly, sitting as the initial chamber that received the impeachment motion, voting in the affirmative for the impeachment motion, no-brainer. The Senate, as a trial chamber, my lord, Articles 94 and 95 donating powers to Senate and to the National Assembly respectively, the Senate then proceeded to afford an opportunity. And I want to just demonstrate, my Lord, that Article 1(2) of the Constitution designates Senate as the National Assembly as speaking for the people under Article 1. Because the people may either access their powers directly or through their elected representatives. So my Lord must read the Constitution in the sense that the Constitution then, speaking through the people, Senate was the trial chamber that undertook the trial as by the Constitution contemplated. My Lord, what happened on the 16th was the commencement of the trial. And it's important to respond to this factual question, that the petitioner participated in the entire trial. Only the petitioner, my lords, had the opportunity to cross-examine all the witnesses presented by the National Assembly that presented his case before the Senate. Senate sitting as a trial chamber as a whole, and therefore as a quasi-judicial body. Each senator, considering the allegations and bundles served to every senator prior to the trial. My lords, it was on the 17th, and this is an important distinction. At 2:30 p.m. after Senate had adjourned at 1:15 p.m., that Senior Counsel Paul Mwite presented to Senate an adjournment on the basis that he could not trace the petition of the Deputy President at the time. He informed the Senate that he had learned of his client's illness but did not reach him. He then sought an adjournment to 5 p.m. He had 2.5 hours to trace his client. My lords, there's a curious point here, and this is important, my lords. The provisions of Article 145, 5, and 6, and I want to refer to those articles, provide, my lord, that at an impeachment hearing before Senate, a party may be represented. 145.5, the President or Deputy President shall have the right to appear and be represented before the special committee during investigations. This article was wholly satisfied because the Deputy President was present throughout the trial. My lord, then Article 145.6A and B then step in. If the claims have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. My lord, Senate accorded the Deputy President an opportunity to be heard. How was that accorded, my lords? That was accorded, my lord, first to be heard through the pleadings filed in Senate. That is one. But number two, my lord, he was present during the entire presentation of the case by the National Assembly. But third, my lord, he was given and afforded an adjournment at 2:30, from 1 p.m. to 2:30. At 2:30, he was accorded an adjournment to come back at 5 p.m. My lord, what happened at 5 p.m. is summarized at paragraphs 25 to 28 of our submissions, and it goes like this, my lord. At 5 p.m., my lords, the Deputy President, the counsel for the Deputy President, Senior Counsel Paul Mwite, submitted or told Senate that he could not trace his client, but that he had been admitted at Care Nostro. He neither presented a medical report nor a report from any doctor. And that is an important observation. But beyond failing to present any document to demonstrate the truthfulness of the health status of the Deputy President, my lord, counsel and his team, Senior Counsel Paul Mwite, Eminent Counsel Elisha Ongoya, and the entire team proceeded to walk out. And why did they proceed to walk out, my lord? Perhaps they did not read the wording of the Constitution and or the standing orders. Because a party, my lords, may be presented or may be present at trial by himself or through an advocate or representative. In this case, my lord, every opportunity was presented to the respondents to present, but they opted, my lord, not to proceed and not to provide any document to Senate at that point to, my lord, confirm, my lord, at the point that their client or the deputy president in that matter was unwell and admitted. Senate then proceeded, my lords, to vote on that question. My lord, this is where Standing Order 85 comes in, and Rule 6 and 7. I will elaborate. Number one, my lord, under Standing Order 85, senators on a procedural motion may vote by acclamation. That vote was carried and Senate then voted to proceed. My lord, the catch here is Rule 12 of the rules that govern the proceedings. Once the 16th and the 17th of October 2024 were gazetted as the days that we had to proceed, that Senate proceeded, my lord, the proceedings had to be sequential and could not be stopped because of the requirement that the proceedings were time-bound and were to conclude in 10 days. The last day, my lord, that the proceedings were to conclude was the Saturday, the next day. My lord, unfortunately, Senior Counsel Mwite, and the Hansard will demonstrate this, my lord, had applied for an adjournment to the following Tuesday. My lord, we have demonstrated that the petitioner dragged the carpet from his own feet, deliberately decided to sabotage his own appearance when he had been in court in Senate for the last 2 days up to 1:15 p.m. before deciding not to be reachable by his entire team and the team making it worse by disappearing. My lords and your leadership, the petitioner had taken part in the cross-examination of all the parties. No case, my lord, has been presented before you that one, there was a violation of the standing orders of Senate. That's number one. Number two, that Senate did not consider some material defense to any of the charges that were proffered against the deputy president. My lord, I just want to, for clarity of thought, submit that even on the submission that my learned friend Mr. Masharia made before this court, that there was additional evidence that was entertained by the Speaker under Rule 6 and 7 by hearing a witness called Mr. Njomo. I remember that submission, my lord. My lord, that was a substantiation of a charge on economic crimes that failed. Only, my lords, 5 out of the 11 charges proffered against the deputy president petitioner hearing succeeded. Only 5 out of the 11 charges. How else can Senate have been judicious? It threw out 6 charges. None of the petitions brought before you seems to commend Senate for standing its high ground and throwing out 6 of the charges. And that is what good faith would mean, my lord. That out of the 6 charges, my lord, the deputy president was convicted on the gross violation of Articles 10(2)(ab), 27 and 129 on the shareholding remark. He was also convicted on the other grounds on national cohesion and on the question that is live before this court, my lord, that is on violating his code that requires him to undertake certain function and undermining the function of the National Security Intelligence Service. Ms. Kimotho of Kimotho and Company Advocates would want the Deputy President to apologize on that count. That's a live matter. But my lord, in the grant of conservatory orders, I submit, and this is because I argued Munya. I argued Wajir, I argued Munya, I argued Mate. So I'm an authority in this area, clearly. My Lord, on the principles that the court considered, the Supreme Court considered in the Munya case, public interest, I think on the scales, weighed highest, that this court must take into account the import of a conservatory order issued ex parte against public interest. My Lord, this is a country that is built on the Constitution of Kenya 2010 with a president whose powers are defined under Article 131 of the Constitution. And Article 131 as a rider that the president's role as the chief executive of the country shall be performed by himself directly and through delegation by the deputy president. This country, therefore, cannot contemplate an interregnum. That means space of power. An interregnum is not contemplated by the Constitution. The position of the deputy president, my lords and my lady, must therefore be filled at all times. And that is why the applicants know well that this country must move on and have a deputy president sworn in because of the dictates of Article 131 of the Constitution. My lady and my lords, a conservatory order is therefore inconceivable in the terms defined in the Munya case. A conservatory order of the nature issued by Justice Mwongo is not only unfeasible, but flies in the face of principles of public interest. The interest in Meru County then was to avoid an interregnum in the governance structure so that Meru County could not collapse. And we took the bold measure to go to court at that time to protect women. This court would only use that authority to support the appointment of His Excellency Honorable Professor Kivure Kidukiro, so that this country moves to the second level. I would urge you to discharge the conservatory order on that principle alone, that the wider public interest is greater than the interest of the former Deputy President of the Republic of Kenya. My Lord, wherein would his remedies lie? Malayan Friendly Body will submit. If it is a salary of 1 month, that would be compensable by damages. If it is a week's salary that is 6 that I should have been or to have been Deputy President, that would be compensated in monetary terms. But this country, my Lord, cannot be at a standstill and be held through litigation, because we need to have that position filled. My Lord, if I move to the other point, my Lord, we have submitted that since every opportunity was accorded to the Deputy President to present his case, and that he failed to present his case, my Lord, every argument before this court by my learned friends on the import of the processes of an impeachment fall on their back. They fall on their back, my Lord, because the authority in Mike Mbuvi Sonko and Nairobi City County Assembly, and again I argued this one, my Lord. In part, I was in this matter. In this case, my Lord, the impeachment was upheld. In this case, Michael Mbuvi Sonko had sought to fault the process leading to the impeachment because there were no reasons given for the impeachment. The Court of Appeal rightly stating that 1, there was the Hansard that contained reasons. 2, my Lord, in terms of an impeachment, my Lord, Mike Mbuvi Sonko was challenging the approach where the Senate sat as a whole, as a committee of the whole. The court finding, my Lord, that that is an option that is open to Senate and cannot speak to the lawfulness or otherwise. Counsel on the other side submitted that there was need for a committee. Senate, in its proceedings, my Lord, in its wisdom, had voted to proceed through the whole House and accorded the petitioner all his rights that were due to him at the initial stage, only for the petitioner not to avail himself to take advantage of the second opportunity to be had. My Lord, we submit, my Lord, that unless the processes of Senate are faulted by my learned friends, the impeachment became final when the vote was taken before midnight on the 17th. And His Excellency, the Deputy President, DP Gachagua, stood impeached henceforth. Unfortunately, my lords, this is an impeachment which has no comeback. It is like a death. You have died. You can't come back to life. But you can have certain claims in succession. And that is why we have the law of succession. Rights and remedies then come into question. My Lord, set aside the conservatory orders. Let us move on, my lords. The bigger public interest tilts in favor of the appointment of His Excellency Professor Kithure Kindiki, a very good man. Thank you, my lords.
Thank you.
My Lord and my Lady, my name is Modomi Nkolu for the second interested party, and to that end, we have filed a notice of preliminary objection dated the 24th of October, the year 2024. We have, in addition to that, filed a list and bundle of authorities on that preliminary objection, and that list and bundle is dated the 25th day of October 2024, and pursuant to your directions, those are the bundles, my Lord. I would suggest you hold them close to you because I'll be referring to them shortly. We have, in addition, filed written submissions, skeleton submissions dated the 27th day of October 2024. Before I delve into the PO, my Lord, a suggestion was made to you. I had forgotten to tell you, my Lord, that I appear for the second interested party together with my learned friend, Mr. Stephen Ogola. Before I go to the PO, my Lord, a number of things were said by my friends and learned friends. I mean it because we are both friends in addition to being learned. One of the things you were told is to laugh at me for raising this PO. The other thing you were told is that the PO was determined in some rulings and directions you issued. And our simple answer, my Lord, is that unless I am mistaken, observations made by the court at the ex parte stage before full benefit of argument from all sides cannot be the subject of a submission that the issue is settled. But if you listen to me why we have raised this PO and you find that I deserve to be laughed at, it's okay. My Lord, our PO makes only 3 interrelated points. The point number 1, which you'll find in paragraph 1 of our written submission, is that the High Court's jurisdiction under Article 23, which governs human rights litigation, and Article 165, which is about enforcement of the Constitution to confirm whether anything. I'm here to tell you very shortly, my lords, the word anything does not actually mean anything in the literal sense, and specifically to tell you that your jurisdiction under that Article 165 does not extend to disputes as to the impeachment of the president and the deputy president. Yes, the court has jurisdiction to enforce human rights. The court has jurisdiction to confirm whether anything allegedly done in the name of the Constitution is constitutional, but our submission is that that apparently very broad jurisdiction does not extend to a dispute as to the impeachment of the president or the deputy president of the republic. And that is the point made in paragraphs 1 all the way to 7 of our preliminary objection. Number 2, point number 2. This court, and indeed all other courts of the Republic of Kenya, have no jurisdiction to entertain a dispute as to the impeachment of the president and the deputy president. But if we are wrong in that submission, my lord, because I have been wrong many times, we make the submission that the only court that would conceivably, arguably, mark my words, conceivably and arguably have jurisdiction on this dispute is the Supreme Court. And that is the subject of paragraph 8 of our preliminary objection. My lord, why do we say that this court, though we acknowledge its broad jurisdiction under Article 23 and 165, does not extend to presidential impeachment disputes? The reasons, my lords, are set in paragraph 6 of our submissions. And the simple point is this: that our Constitution denies this court, the High Court jurisdiction, on countless matters that would fall under Chapter 4 on the Bill of Rights. Case in point, presidential elections involve human rights under Article 38. It is clear in the Constitution that this court has no jurisdiction over a dispute relating to a presidential election. Even if someone were to come here and say that he was denied his Article 38, which is a human right under that election. My lord, it is clear by dint of Article 58, sub-Article 5, that this court has no jurisdiction to hear a dispute as to a declaration of a state of emergency. My learned friend, Mr. Ngwe, talks of the word decency. I hope we are all sufficiently decent to acknowledge that nothing invades the entire regime of human rights than a declaration of emergency. That declaration can affect the right to assembly, to expression, to basically everything. And yet the Constitution is clear. If you have a dispute as to that matter, never mind that it has abrogated the entire Bill of Rights, the court you go to is not the High Court. It is the Supreme Court. My lord, property is a matter of the Bill of Rights, Article 40. It is clear from our Article 162 that if you have a problem in that regard, or to do with the environment, which is also a human rights matter, you go to the Environment and Land Court. So, my lord, I'm here very humbly to tell you, the mere fact that someone has run to use screaming Article 23, Article 165, does not without more mean that this court as jurisdiction to hear that matter. In other words, my Lord, for you to exercise jurisdiction over this matter, you've been told many matters, and as far as we are concerned, the matter before you, the substratum, is the impeachment. These things you're being told about Professor Kindiki are diversionaries or subsidiaries, because without the impeachment, we will not be talking about Kindiki. So the substratum of the dispute before you is impeachment. And our point, my Lord, in the absence of an express grant of jurisdiction on this court, on the substratum of this dispute, on the subject of this dispute, which reminds me of Professor Gideon Muigei's issue about justiciability, then you have no jurisdiction. Luckily, my Lord, I hope we all agree that there is no clause of our Constitution that confers on this court jurisdiction to entertain the dispute before you. Which means, therefore, the question is whether nonetheless you have that jurisdiction, given your broad powers under Article 23 and 165. Luckily, my Lord, our Constitution was the product of a 20-year process that we call the constitutional process. And because it is in black and white, I invite you to go to page 5 of our Bado, my Lord, the Bado of Authorities. We have produced you, or rather before you, extracts of the Boma's constitutional, Boma's draft constitution. It confirms to us, if you go to page 6 with me, that during the constitutional process, Kenyans actually agonized over whether this matter should be handled in the court and which court. And it's there in black and white, Article 187 on page 6. It says the Supreme Court shall have exclusive, that must mean to the exclusion of every other court, including this one, A, Roman 2, disputes arising from the process of the impeachment of the president. So when we were having our debates through the Boma's process, there was a decision, it's there in black and white, that there will be judicial review, not before this court, but in the Supreme Court. Of course we know, my lords, the Boma's draft was one of many. The next draft that was generated in that process is at page 7 of our Bado, the harmonized draft constitution. At page 8, again, clause 201 of that draft constitution, it is clear there in Article 201, sub-article 4, that the Supreme Court has, paragraph A, exclusive, at the line, exclusive. We move from that document, and luckily, my lords, the bench, to me, should be familiar with this process, to a document that went to the 2005 referendum, which was the Wako draft. We have produced it at page 10 of our Bado. This document is special, my lord, in the sense that it was subjected to a referendum before the people of Kenya. And again, you'll find there, Article 184, Kenyans were still toying with the idea that the courts can interfere with this process. But what I want you to mark again on page 11 is that the court that had been envisioned is the Supreme Court, not the High Court. We all, of course, know that draft was rejected by the people of Kenya, and that must mean, because this is the draft that reached the referendum, that the people of Kenya also rejected this rule of judicial intervention in this problem before you. Why do I say so? The next document is now the official constitution we have today, which is the Constitution of Kenya 2010. And it has no clause conferring jurisdiction on this court or even the Supreme Court. And since that rule was always on the table, my lord, but was dropped from the final draft, we must take it that the final decision the people of Kenya made at the referendum of 2010 was that there would be no judicial intervention in the dispute of the nature before you. You are told that we have cited Article 144, yet it is irrelevant. Let's see shortly whether it's irrelevant. We have produced Article 144 on page 13 of our Bado. My lords and my lady, you can only remove the president and the deputy president through two routes. Either the route of Article 144 or Article 145. We are only mentioning 144 to help us answer, in the absence of express jurisdiction, whether there is inferred jurisdiction. And when you check 144, one of the curious rules it tells you, 144, Article 144.8 of our Constitution, is that the report of the tribunal shall be final and not subject to appeal. And if the tribunal reports that the president is capable of performing the functions of the office, the speaker shall also communicate. And of course, it goes on to hold that if it finds the president is either insane or suffers an infirmity of body, then the Senate shall vote. Something curious here, my lord, that our Senate can vote to retain a president found by a medical tribunal to be insane, and our Constitution says that decision cannot be challenged in any court or tribunal. Those are not my words. But more curiously, this rule is also repeated, my lord, in Article 165. And for me, what is notable, my lord, is, the Constitution speaks to an issue once. It has spoken about this issue of 144 in 144.9. And when you go to 165 again, it says this court has jurisdiction to hear an appeal from a tribunal on removal from office, except the tribunal under 144. I don't know, but it must count for something that those who drafted our Constitution decided to deny jurisdiction not just once, but twice. So the $1 million question, my lord, if this court has been denied jurisdiction twice for the process under Article 144, on what basis can it assume jurisdiction for a process under Article 145 in the absence of express conferment of that jurisdiction, and in the face of the multiple ousters I took you through, where the Constitution says in black and white, this matter may be about the Constitution, this matter may be about the Bill of Rights, but the High Court has no jurisdiction. That's what we mean when we say in our PO, my lord, that there is Supreme Court jurisprudence in this country. I'm addressing you now on the authority in advisory opinion number 2, I believe, of 2011. I don't know whether Professor Tom Ojeda was involved. But my lord, we were told in that decision that jurisdiction cannot be arrogated through the craft of interpretation. What the petitioner and those in support of his cause are inviting the High Court to do is to arrogate to itself jurisdiction of a dispute or by the impeachment of the president through the craft of interpretation, through the craft of stealth, through the craft of sophistry. Jurisdiction is something the court either has or does not have. It cannot be inferred. Professor Ojende is telling me other things one must either have or not have. There is no middle ground. But I suppose he wants me to fall into trouble with the court, so I won't mention them. My Lord, let's go to the decision in Nixon versus United States, which is at page 20. Again, you are told to laugh at me because this decision is from the 19th century. I will invite you to note it's a decision issued in the year 1993. I was in upper primary school in 1993, and my students say I'm still fairly young. So this is not a decision from the 19th century, my Lord. But I also want to point to you, 1993 is so recent, coming from the United States, a country that has had a constitution running for close to 300 years, now and counting. Why this decision is important, my Lord, is several reasons. One, it is a decision from the United States Supreme Court. Two, our law on impeachment, and I hope again we have to quote my good friend Ongoya, the decency to agree that it is from the United States Constitution we borrowed Article 144 and 145. Even if you check the rule now in issue, Rule 11 here, Rule 11 in this decision of the Senate. So this decision, to the extent that it comes from the highest court of the country from which we got this idea now before you of impeachment, must surely be persuasive, even if not binding on you. But more important, it is also about impeachment. What happened in this decision, my Lord, is quite interesting. The person who had been impeached was a judge of a federal court in the US. He was sent to prison, but refused to resign from his judicial office. And because in the US, judges hold office for life, to the extent that he refused to resign, it meant the US Treasury was bound to continue paying his salary and emoluments while he was in jail. And of course, that absurdity was not going to be let go. The United States Parliament, called Congress, the House of Representatives and the Senate, took up impeachment and impeached this judge. But when you follow the holdings in this case, my Lord, they say at page 20 of Wabadu that a controversy is non-justiciable where there is a textually demonstrable constitutional commitment of the issue to a coordinate political department of government, or when you lack judicially discoverable or manageable standards or remedies for resolving it. I don't need to belabor the point. When you read the case, the Sonko case and the Wabora case, that is exactly what our Supreme Court has said, following this decision, that impeachment is textually committed. Those are not my words. They are the words of the Supreme Court of the US, the Supreme Court of the Republic of Kenya. And my Lord, we submit under Article 144, or rather 145, impeachment is textually committed to the Senate. But they also say the language and structure of the Constitution confirm that textual commitment of this dispute. More importantly, which is what the Attorney General, Emeritus Professor Muige, if you go to page 21, my Lord, you are told justiciability is also refuted by the lack of finality inherent in exposing the country's political life, particularly if the president were impeached to months or perhaps years of chaos during judicial review of Senate. We already know, I've been telling you how the other side wants to grind the wheels. We are told by the Supreme Court, my Lord, this specter of the country being held on tenterhooks as this matter is fought here, is fought in the Court of Appeal. The average lifespan of a case in our Court of Appeal is 3 to 5 years, the last time I checked. Then going to the Supreme Court, we are being told the political life of a country cannot be held at ransom awaiting judicial determination. And more importantly, lastly, because my seniors are telling me I've been talking too much, so that I take my seat before they reprimand me, I want to refer you to page 32 of our Bado. And the reason I'm referring it to you, my Lord, is many people will genuinely be shocked by this idea that a dispute like this is not justiciable. But there are good policy reasons for it. And if you read our page 32, which is that decision in Nixon versus United States, it tells you in black and white, there are sufficient safeguards embedded in the Constitution, including majorities, minimum voting thresholds required at every stage of that process, including the holding of a trial, including calling and cross-examination of witnesses. And because those safeguards, especially at the Senate, are in the nature of a trial, that's why Chief Justice Rehnquist tells us here that nobody should have to make every weather of the idea that this type of dispute is not justiciable. Lastly, you are told about political question doctrine and many things. I will invite you to note the courts of Kenya endorsed this doctrine as early as 2005. Again, the authority is on page 51 of our Bado. I don't have time to take you through it. We have produced the Sonko decisions. We have the citations, the quotes we've lifted in our written submissions. And all we are telling you, my Lord, when all is said and done, is to do either of two things. Hold you have no jurisdiction. The consequence would be that these petitions must be struck out. The conservatory order must fall by the wayside, having been issued by a court lacking jurisdiction. But if my lords find that too heavy and too radical, and therefore unacceptable to this court, I am giving you the alternative. If we must infer jurisdiction, because that's what you're being asked, let's infer it at the Supreme Court, which is the global practice, so that the matter is held of this nature is handled once and for all without subjecting the country's political life. That is the public interest we have just been told from the Supreme Court of the United States. That's all, unless there is a question for me.
Thank you.
My Lord, my lady, if it may please you, my name is Milimo. My Lord, I'm here to address you on 3 grounds. Specifically, my Lord, one on public participation. The second issue, my Lord, I'll be addressing you on is fair hearing, with reference, my Lord, to the National Assembly. And lastly, on the nominee, my Lord, the deputy presidential nominee. My Lord, on the first point of public participation, you shall note first, my Lord, that there is no one in the petition before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my Lord, is that it's common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my Lord, dictated by Article 118B of the Constitution. And my Lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my Lord, to refer to the Supreme Court BAT decision. And specifically, my Lord, at page 45 of that decision, which we have attached, my Lord, to the first respondents supplementary list and bundle of authorities dated 28th of this month. My Lord, the second authority that I will refer you to on matters public participation is the recent authority, my Lord, that was rendered last week by the High Court in the affordable housing decision, my Lord, that is petition number A154 of 2024, and specifically, my Lord, at pages 178 to 179, rather to 184 of that decision. My Lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my Lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my Lord, has been undertaken in the history of this country. And my Lord, I will refer you to the annexed public participation report, and specifically, my Lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And my Lord, very quickly, you note that over 224,000 people my Lord, over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my Lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My Lord, I'm trying to establish the fact that heavy weather was made, my Lord, on the fact that there was no public
We have
participation.
noted those heavy weathers, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the issue before the courts. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my Lord, I stand guided. And then that...
In other words, Mr. Milimo, you may spare us the submission on the sufficiency of the public participation.
Correct, my Lord. Yes, my Lord, I stand guided, and I was just going, my Lord, to refer you to one authority that we had, my Lord, attached as authority number 1 in the supplementary list of authorities. If you are to look at page 4 of that authority, my Lord, the sufficiency or otherwise of public participation exercise, my Lord, is to be determined at the main trial. And my Lord, therefore, I would agree with you that all I need to do, my Lord, is to refer you to the report that I've indicated, my Lord, that it appears at page 427, specifically the findings, my Lord, to 455 of the replying affidavit. But, my Lord, allow me just to pick one thing out of that report. You are particularly, my Lord, referred to one of the constituencies, specifically, my Lord, Keio South constituency, where my learned colleagues, my Lord, raised issues that indeed the figures did not tally. My Lord, first, you shall note that the figures that were quoted by the petition, my Lord, are contained nowhere in the public participation report that have been submitted before you. My Lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My Lord, Keio South views, my Lord, are submitted are to be found firstly at page 289 of the report, my Lord, and it appears as item number 95 and this goes specifically, my lord, to the hand-delivered and email views, where it was indicated that, my lord, there was a total of 465 responses, and out of those, my lord, 455 were in support. That is what, my lord, is contained in the report as the first limb. The second limb, my lord, is for those who participated in the public hearings of the 4th, my lord, of October, and is found at page 331. Same KO South constituency. And, my lord, it's indicated that a total of 355 people did, my lord, attend that public hearing. And out of those, 352 persons, my lord, supported the motion. Lastly, on that point, my lord, is to refer you to page 440 of the replying affidavit, my lord, where you shall note, not 440, my lord, I'm sorry, page 439, where, my lord, you shall note that the total responses in respect of KO South constituency were 820. And that out of those, my lord, in support were 807. So, my lord, the views are submitted, or the submissions are submitted by my lord and colleagues, my lord, do not find any favor in the report, and therefore, my lord, I'll urge you that you do ignore them. My lord, I also need to point out that public participation, my lord, is not a referendum. As well understood, my lord. And that in the words, my lord, of your learned brother, justices and sisters, my lord, in the affordable housing decision, public participation does not, my lord, necessarily mean that everyone in the country must give their opinions. My lord, that is paragraph 175 of the affordable housing decision. And that, my lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my lord, to submit their views. And, my lord, you shall note that in the report, all that was done by the National Assembly. And therefore, in the fullness of time, my lord, we shall demonstrate before you that there's absolutely no arguable point, and the public participation exercise that was conducted, my lord, by the National Assembly was not only meaningful, but was sufficient both qualitatively and quantitatively. My lord, the other issue that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my lord, that elections are conducted at the polling stations. My lord, that submission is not true. The presidential, my lord, elections are provided for in terms of being conducted, my lord, at Article 138(2), where it states, my lord, that the elections are at the constituency level and not at the polling station. My lord, the other issue that arose from the submissions from my Iranian colleagues is whether, my lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My lord, my answer to that is simple. That first, my lord, the public participation exercise commenced on 2nd of October all the way to 5th. And, my lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my lord, that that response could have been availed to the public. Secondly, that, my lord, the National Assembly only avails what is in its possession. And therefore, at that point, my lord, the National Assembly could not have been accused of not, my lord, presenting to the public what had not presented to it. But more important, my lord, there is no legal requirement, and none was cited by our learned colleague, that dictates that the National Assembly had a duty to present, my lord, that response to the public during public participation. And last, my lord, nothing stopped the first petitioner, my lord, from himself presenting that response to the public, as he did, my lord, on the eve of the hearing of proceedings at the National Assembly. The last point, my lord, on public participation was whether, my lord, the Senate ought to have conducted the public participation exercise? And my Lord, my answer to that is this, that under Article 118B, my Lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my Lord, Parliament under Article 93(1) refers to both the Senate and the National Assembly. And, my Lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my Lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my Lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my Lord, then it means that even this court sitting in exercise of a judicial function, it could be required, my Lord, to undertake the public participation exercise.
Mr. Melema, we only entertained you on these submissions because we had entertained other people earlier. That is the only reason we are listening to you.
I thank you, my Lord. But I'm winding up on that, my Lord. Yes. My Lord, the second issue that, my Lord, I'll invite your attention to is on the subject, my Lord, of fair hearing. My Lord, and on that limb, there was a challenge, my Lord, to the standing orders of the National Assembly. My Lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my Lord, and that at this stage, being an intellectual stage, this court, my Lord, has no power to invalidate those standing orders, my Lord. In the fullness of time during, my Lord, the main hearing, we shall demonstrate to you that those standing orders, my Lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my Lord, is to implement those articles of the Constitution. The other issue, my Lord, that was raised was about impartiality of the Speaker of the National Assembly, my Lord. Yes, and my Lord, you shall note that the Speaker of the National Assembly, my Lord, has no vote in the proceedings, and that is, my Lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my Lord, is not a valid submission. And, my Lord, more importantly, my Lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And, my Lord, he did file a substantive response to the notice of motion. And more importantly, my Lord, he was given 2 hours to present oral representations. That opportunity he took, my Lord. And therefore, the question of there having, my Lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My Lord, my last point is on the nomination, my Lord, of my good teacher, Professor Kindiki. And, my Lord, the issue was whether there ought to have been, my Lord, an approval process at the National Assembly, and whether, my Lord, there ought to have been public participation, as well as, my Lord, the timelines that were invoked, my Lord, to process the good professor. Yes, my Lord, all I need, my Lord, to bring to your attention is there was a ruling, my Lord, by the Speaker of the National Assembly that we attached to the first respondent supplemental list and band of authorities, dated, my Lord, the 28th of October this year. And, my Lord, you shall note that in that communication, the Speaker did address all those issues, my Lord. The communication, my Lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my Lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, my Lord, to refer to it when you retire. My colleague, Mr. Macharia, my Lord, on a light note, told the court that, my Lord, I would have said Weta Tosha. My Lord, I'll say that in 2032 when the right comes. I thank you, my Lord, unless your Lordship have any questions.
My lords and my lady, I'll proceed from where my learned friend Mr. Milima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Joroge on the 21st of October 2024. My lords, we also have submissions in response to the application seeking conservatory orders dated the 27th of October 2024. And finally, the list and digest of authorities dated 27th of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. In understanding the application and the prayers that are currently live before the court, permit me to draw your attention to the application filed by our learned colleagues in the matter 565 for 2024 for just one purpose only. The application has a total of about 13 prayers. The prayer number 1 all the way to prayer number 10 have been spent. In other words, they've been overtaken by events. The last prayer, which perhaps would have been relevant for purpose of understanding what I'm trying to get to, is prayer number 9, which talks about that pending the hearing and determination of a petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of a person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William Samoei Ruto, to fill the vacancy of the office of the Deputy President of the Republic of Kenya. That prayer is equally overtaken by events. The last prayer is for deletion of what they call falsehoods to various persons and institutions. It then follows, my lords and my lady, that the petitioner, His Excellency Rigathi Gachagua, has no prayer that is live before you in relation to the question of conservatory order. Looking at the application number A015, the only prayer that is live before you is prayer number C and prayer number E, both of which deal with the question of swearing in of the second interested party appointed by the President and approved by the National Assembly, they say, from assuming the office of the Deputy President. It then is our submission that the threshold question, the arguability question, the nugatory question needs to then address the issue of swearing in. I will then straight go to the issue of swearing in. My lords and my lady, we've spoken to the provisions of Article 145(7) 145.7 very clearly indicates that if at least 2/3 of the members of a Senate vote to uphold any impeachment charge, the president shall cease to hold office. May I add to the submissions that have been made previously that that provision is a self-executing provision. You do not need more. It is not an action of the Senate, it is an action of the Constitution itself. The first question that then we would want to ask ourselves this afternoon is, in light of view of such an express provision of the Constitution, is it tenable that an order of this court would issue to stop it? Let me take as one step further to remind us that at the point at which the deputy president was impeached, he then acquired a constitutional blemish. And we say a constitutional blemish because under the provisions of Article 150, all the charges that were substantiated as against him, including the question of gross violation of the provisions of this Constitution, serious reasons to believe that the deputy president committed a crime under the national or international law, and gross misconduct, then were issues that would be said to have informed his constitutional standing. Now, where am I going with that? I'm trying to make the point that when the Constitution, therefore, has put a dot or a blemish on you, then certainly you become unsuitable to hold office by dint of Chapter 6 of our Constitution. That is, specifically, I would draw your attentions to the provisions of Article 73, Subarticle 1, which says, talks about leadership and integrity, responsibility of leadership. It says, authority assigned to a state officer is a public trust to be exercised in a manner that, 3, brings honor to the nation and dignity of the office. To the extent that those grounds were established under Article 150, it simply means that the person of His Excellency the Deputy President therefore lost the capacity. And why that is important is then, as you consider this question as to whether to grant the conservatory orders or not, would he be one person who would possibly be considered for that situation? And our answer is a simple no. Permit me to speak to the issue of now Article 149. Article 149 reads, within 14 days after vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. First point I would want to make, just to complement what my learned friend Mr. Muthomi has spoken to, as to the justiciability. If the Constitution says that within 14 days of coming into play of Article 145.7, is it practical, is it tenable that within those 14 days, if a party were to have come to court, then going through the hierarchy of the High Court, the Court of Appeal, and the Supreme Court, any dispute touching on that question of nomination would have been resolved? That then speaks to the architecture of our Constitution, to the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Subarticle 2 speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, we then relate this to the events of first Article 94, Subarticle 2, which says the role of Parliament shall be Parliament manifests the diversity of the nation, represents the will of a people, and exercises their sovereignty. What point am I trying to make? A lot of heavy weather has been made about the candidate who has been presented for purposes of approval under this constitution. Now, one of the issues that has been raised is that there was no public participation in relation to the candidature of Professor Kithure Kindiki. My lord and my lady, allow me to just take us very quickly to the provisions of Article 149 to provide some bit of context. That within 14 days, allow me to just read it again, within 14 days after a vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days. Vote is the word used. I want to persuade you, my lords and my lady, that the action that the members of the National Assembly would be taking pursuant to this 149.9 flows from the delegated authority under Article 1, Subarticle 2. It also flows to the role of parliamentarians under Article 94, Subarticle 2, to exercise the will of the people of Kenya, to exercise their sovereignty. In other words, that is a choice that the National Assembly is making as the representatives of their people. And why that is important is the very question that follows, is when making that decision, is public participation an imperative? Our answer, my lords and my lady, is a straight no. And so that then I give you context. Let me give us what happens in the ordinary elections, and which will be at Article 148. Article 148, Subarticle 1 reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at Subarticle 2 that for purposes of Clause 1, there shall be no separate nomination process for the deputy president, and Article 137(1)(d) shall not apply to the candidate of a deputy president. What then do we read from that? It means that a simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that that is what happens, we don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of a president, Article 132, Subarticle 2, under the functions of a president, the Constitution says, the president shall nominate and with approval of a National Assembly appoint or may dismiss A, cabinet secretaries, B, attorney general, C, the secretary to the cabinet in accordance with Article 154, and the principal secretaries in accordance with Article 155. It is in that instant that then public participation is called for. So that then when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is it is a submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first past the poll. In other words, at the point of voting, do the parliamentarians vote to support or a majority of them support the nomination? That is the simple question that will be presented before you for determination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2B, that if the office of deputy president is vacant or the deputy president is unable to assume the office of a president, the Speaker of the National Assembly shall act as a president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to the court, would it be in the interest of, now that it is clear that there is no occupant of the office of a deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article because we want to issue orders that would stay the filling of that office? In our understanding, my lords and my lady, that would be pushing the Constitution a little too far. It should not be lost on us that this same petitioner, the mover of this very petition, during the discussions around the motion itself, we had terms like kufa dereva, kufa makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And we're saying crisis because we live in this country and we know that as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the electoral commission. What then does that mean? It means potentially that the first person to get to Uhuru Park and get sworn will be the president. My lords and my lady, is that a position we would want to allow the country to get into? Permit me to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses office, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process so that then the competing interests are balanced in a way that ensures the stability of the country. And because they're deep, it's very interesting and very, something to be very proud about to be Kenyans today, that we are talking about such sensitive issues in this sort of a civil environment. My lords and my lady, in other places, when we talk about this sort of transitions, these are constitutional transitions, they end up subjecting the populace to more difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that have been sought or not? My lords and my lady, the constitutionalism speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decision we take is such as to ensure that there is stability within the country and that the country is given an opportunity to move on. My lords and my lady, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of jurisprudence about Jeremy Bentham, about Arthur Stuart Mill. They were great proponents of utilitarianism as a concept of constitutionalism. May I also invite you to the works and findings of Roscoe Pound, who postulates that the law is supposed to be a tool of social engineering, and that then in its implementation, that social engineering is supposed to help to bring stability within the nation. My lords, my lady, it only follows that for us to achieve that stability, then the orders that were issued under there are ex parte are orders that are supposed to be set aside, the country allowed to move aside. I am most obliged.
Thank you.
My Lord, the presiding judge, as I settle down and begin to make my submissions in opposition to the notices of motion before you, may I kindly request the court to ask that that light, which is a bit blinding, be either angled further up or turned off completely.
The light has had.
I guess that makes it a smart light, my Lord. It can understand and react. My Lord, the applications before you for conservatory orders this evening are opposed. For the record, I am Paul Nyamodi. I am on record together with my learned friend, Mr. Gumbo, for the second respondent. And my Lord, I wish to commence my submission by saying that the task before you this evening is a rather simple task. Listening to my colleagues making their submissions, one would be forgiven if they formed the impression that what was for hearing before you was the petition proper. It is not. What is before you for hearing are two applications for conservatory orders. And my Lord, it is my submission that the criteria, which you will no doubt consider when you retire to consider your decision in this matter, is straightforward. Is there, do the petitions before you disclose inherent merit? Would those petitions be rendered nugatory if the conservatory orders that are sought are not granted? And lastly, and most importantly, is it in the public interest to grant the conservatory orders that are sought? I wish to state that the purpose of a conservatory order, or the ultimate beneficiary of a conservatory order, is the court, and not the party that seeks the conservatory order. I say so because the purpose of a conservatory order, my lords, is to preserve a situation so that the orders of the court upon conclusion of the hearing of the petition are efficacious. That is not achieved by returning anybody to office. That is merely achieved by maintaining a certain status quo for the benefit of the court. So anybody who seeks to persuade you that they can be returned to office by a conservatory order, then perhaps has misunderstood what indeed a conservatory order is. My lords, just to pull the strands together from the submissions that have been made by my learned colleagues for the respondent, and the context in which I urge my lords, my lady, to view those submissions, is that they have spoken to the first ground. They have spoken to the first ground in Peter Munya. They have spoken, or they are responding to the question, is there inherent merit in the petitions that are before you? All the submissions about public participation, all the submissions about the Article 50 rights are all in an attempt to persuade you that there is no inherent merit in those petitions. And I don't wish to go back on those, but I wish to just put two issues before you in respect of the question of inherent merit. My lords, my lady, when you retire to consider your decision in this matter, I'm sure you will need no reminding that the issue of, or a merit review of the impeachment process is beyond the ability of this court. So reject any requests from the petitioners to conduct a merit review of the impeachment. What this court is able to do, and I believe that is the decision of the Supreme Court in Sonko, is to carry out a process review. And so that you are, I then submit that in determining whether there is inherent merit, this court must then constrain itself to carrying out a process review. My lords, my lady, the second point I wish to make in respect of inherent merit is this. These petitions arise from a concluded impeachment process. In that impeachment process, as you have heard, there were 11 grounds for impeachment. From those 11 grounds, the Senate rejected 6 and confirmed 5. Out of those 5, 3 grounds, and those are grounds 1, ground 5, and ground 6, turned on the conversation or the issue that has come to be known as the shareholder narrative. Now, the first petitioner does not deny that he said those things that he is alleged to have said. It is my submission that there being no denial as to those utterances from the first petitioner, he acknowledges that he said them. There is an admission from the petitioner that he said those things that he said. Now, those 3 grounds of impeachment flowing from facts that the petitioner has admitted, can there be any inherent merit in a petition that seeks to challenge grounds that he has admitted? Ground 1, ground 5, and ground 6 all flow from the shareholder narrative. It is my submission that there can be no inherent merit in those petitions. The finding by the Senate flows from an admission, and that then takes away the ability of the first petitioner to challenge the Senate's finding. My lords, my lady, I wish to move on to the second ground, or the second issue that you would need to consider when you retire to consider your decision on this matter, and that is the issue of whether the petitions would be rendered nugatory if the conservatory orders that are sought are not granted. And I wish to submit on it with the conjoined issue of what is the appropriate remedy in the circumstances of these petitions. My lords, my ladies, in my preparation for my submissions before you this evening, I came across a pitch of a decision. And I wish to persuade you that the applications before you are for dismissal, and I wish to persuade you by reference to the notices of motion that are before you and to decisions of this court that have been rendered in respect of similar matters. My lords, there is a decision that is in pari materia with this one completely, and I say so for these reasons. The decision, and we have filed it as in a supplementary list of authority, is the decision of the High Court of Kenya in Constitutional Petition number 4 of 2024, Purity Mora Kerira versus the Senate and 8 others. It is a decision of the High Court of Kenya in Nyamira. And it is a decision of your sister, Justice Wilfrida Okoye. We have filed it as a supplementary authority, but I have taken the liberty, because it is important to our submission, to make copies available to the bench, which I wish to just walk you through quickly during my submission. My lords, I submit that that decision is in pari materia with this one for the following reasons. It arises from our impeachment process of the Deputy Governor of Kissy County. As I will demonstrate in a moment, the impeachment was preceded by litigation.